So everyone who's popping on, this is Rex Stratton. Rex is an expert on intellectual property law. He is definitely my go-to with any questions in the subject. And this is a follow-up event to our trademark or our trade secrets and patents event that we did a few weeks ago. So if anyone missed that, feel free to reach out to me at phoebe@bset.co, and I can forward you along my notes and the presentation and packet and all of that. And I'm certainly excited about this topic with copyrights and trademarks and kind of taking a deeper dive into those. So I'll let you take it away, Rex.
I will be happy to. Well, we're going to talk about intellectual property generally, and primarily about copyrights and trademarks. But intellectual property is really protected by four legs of the stool. One's patents, one's trade secrets, the other's copyrights and trademarks. And unfair competition, which we'll talk about, falls under trademarks. So they each protect our stool in a different way. Patents protect ideas, that is, the new articles of manufacture, machines, compositions of matter, and process. So if you have an idea, the only way you're going to be able to protect it is with a patent. The trade secret protects the confidentiality of your idea, including business information, methods and technology, which confidential business lists, production methods, processes, all kinds of things. But you only protect a trade secret by what? Keeping it a secret. Copyrights. Copyrights protect original creative expressions. Remembering patents protect ideas, copyrights protect the expression of an idea fixed in a tangible medium. Trademarks protect words and symbols that identify a single source of goods. And that's important because if you had a trademark and two people were using it, it wouldn't be a trademark because it would not identify a single source. And unfair competition is a subset of trademark law, and it protects unfair business practices. Pretty straightforward. Okay, these are constitutional. Our framers of the Constitution protected both patents and copyrights, and trademarks arise under the Commerce Clause, which is also in Article 1, Section 8. And for there to be a federal trademark, it has to be in commerce regulated by the Congress. So there you can see what it is. International, foreign nations, the several states, and the Indian tribes or Indian nations. Okay, important. And this we talked about last time is intellectual property rights are preclusive. That is, you can prohibit somebody from practicing an invention, using a trademark, making a copy, or using a trade secret. But you can't necessarily practice your own invention or make a copy of your own work or use a trademark if indeed in your using your intellectual property, you are infringing somebody else's intellectual property. That happens all the time in inventions where you have an invention, but to practice your invention, you will have to have a license from some other patent owner who has a part of, has an invention on a part of what you're doing. Copy is the same way. If you want to copyright something, that's great. But if you have to include somebody else's work within your copyright, it's going to be a derivative work. So, copyrights. The copyright gives the owner the right to prevent others from copying the form of expression containing an original work, fixed in a tangible medium. All those are important. It has to be an expression. It has to be original with the author, and it has to be fixed. So if you were to do a really cool dance on a street corner, but it's not recorded in any way, the dance is ephemeral, and you would have no copyright in that dance. It doesn't exist anymore. So protectable rights are broad, include almost anything that you can fix in a tangible medium, regardless of how you're going to affix it. Including, you have a copyright, somebody has a copyright in Mount Rushmore, by the way, that's fixed in a tangible medium. Hopefully there will be no further work up there, but that's a different issue. So if somebody creates something independently, by the way, it is not a copyright infringement. And that's true also of trade secrets, not true of patents, but it's true of trade secrets and copyright. If I create something and I don't have access and it's not to your work and I do it independently, then I will own a copyright in my own work. Okay, example. We're both standing shoulder to shoulder. We're about the same height. And we take a picture of a mountain. And we have identical cameras, but the person next to me chooses a little bit different f-stop and gets a little bit better picture. Maybe the foreground is a little bit blurred out, so it's a lovely piece of art. And mine, because I don't know any better, is just, point and shoot. Now I can make we have the exact same image, essentially. And I have the right to make a copy of my photograph. The person next to me has a right to make a copy of her photograph, because it's Phoebe. Phoebe's taking that picture. Because she's far more artistic than I am. So, but I can't make a copy of Phoebe's picture. We independently created each of our own images. They are virtually identical, except that hers is better. So that's what independent creation is all about. Now, if I sat down and wrote an entire novel, it would be hard to say that my entire novel is independently created if, in fact, I had been reading a novel of Anne Rule and started using a lot of her phraseology and all in my novel. So independent creation is a work that's original, but it's hard to do. Think for a moment of George Harrison's My Dear Lord. Now, George probably didn't sit down to copy somebody else's work, but he was found to have violated a copyright because My Sweet Lord sounded very much like another work, and they were able to prove in court that one was substantially similar of the other. Now, George may not have had any recollection of doing it, but what he did hear was probably an earworm that was set in there a long time ago by having listened to that other work. And that's happens not infrequently. Okay, so some things to know. There is no such thing as a common law copyright. Doesn't exist. Used to, doesn't now. The enforcement of copyright is exclusively in the federal courts. And by the way, somebody says they have a common law copyright. There was a lawyer who, after the Copyright Act of 1976 was adopted, litigated a common law copyright only to find himself being sanctioned at the trial court and the appellate court level big time. The court said, there is no common law copyright. And he says, well, I didn't know that. And the court said, you should have. Registration of a copyright is always with the Copyright Office. And only the United States requires that copyrights be registered.
Hey, Rex, just for a second, your microphone sounds a little muffled.
It's muffled? It is?
It just sounds quiet and muffled.
Oh dear.
Did it come unplugged a bit?
Well, let's do this. We'll turn it off. Computer, how's that?
Much better. Thank you.
Okay, you're not much better, but maybe I am. Okay, now it wants to tell me something.
Sorry about that.
I had this all nicely set up and now I don't. Hang on just a second. Technology is not our friend sometimes.
No, it's not.
And as soon as we try to make changes with it, it makes it really difficult. Well, maybe Phoebe, if you have it up, you can bring it up. I can still
Yeah.
see it, but I can't see my my screen. So it disappeared somewhere in all of this. Oh, here we go. Nope, that's not going to bring it back either. Nope.
I can bring it up in a second.
This happened the other day. I was using Zoom and I had the free one and I ran over my 40 minutes with a group of 5. We're having a board meeting and they put everybody else on hold and I had to go and buy more regular subscription.
So I think I started sharing it. Can everyone see?
There we go.
So let's go forward. Are we here? Where are we?
Yeah, that looks fine.
Okay.
Now, I don't know if you can see me. I can't see you at the moment.
I can see you. Yeah, you can go ahead and just tell me when to advance the slides.
Okay, now I can't, I'm not shared, so you just have it up. So you're going to have to move, keep moving it for me, but that's okay. So next slide. Let's do it the old-fashioned way. Okay, there are 6 exclusive rights under copyright law. One is to reproduce the copyrighted work. Now, why can you reproduce the copyright and others can't? That's because you own the copyright. If 2 or more people own a copyright, then either one of them, as the owner of the copyright, can make a copy. Why? Because they own the copy. And they are not liable to the other for making that copy. However, if you have 2 or more owners of a copyright, then if one of the owners commercially exploits the copyrighted work, 50% of the royalties received would be paid over, or would have to be paid over, to the other copyright owner. So we'll get into why exclusive ownership is important, but that's part of the law. You can prepare a derivative work. What is a derivative work? Well, exactly that. It derives from the copyrighted work. So if you have a book and then you create another book on top of that book that borrows from the former book, that would be a derivative work. You can distribute copies. You can perform the work. You can display the work, and you can perform the work through digital audio transmission. Not something our framers of the Constitution thought of, but it's certainly now a part of the law because of technology. An important concept, and a lot of people don't think of it this way. If I own a copyrighted work, a Picasso, and I own the original, what rights do I have? I have the right to hang it in my house. I might be able to get license to hang it in a artwork display, you know, whatever you want to do it on your wall of your office or whatever. But I don't have a right to make a copy of it, nor do I have a right to display it other than for my own personal use. I can't display it commercially. Let's move on. Okay, copyright is long-lived, 70 years from the death of the author. So if somebody writes a work, it is protected by copyright from the time it is created for the life of the author plus 70 words. If it is made anonymously or pseudonymously, or if it's a work made for hire, then it's 95 years from the date of publication or 120 years from the date of creation, whichever expires first. So copyrights last for a long, long time. And that's important because if you have a copyrighted work that you would like to reproduce for some reason, you have to know either when the author died or when it was created or first published. There are some exceptions now because there's a lot, especially in the photographic area, there's a lot of works that you don't know who took the photograph. Good example, you have somebody that's taken a picture 40 years ago of people skiing at Mad River Glen. We have no idea who took that picture, but it's posted on the wall of the ski lodge. And so it is, well, you know, it's an orphan. And in an orphan work, there's provisions in the Copyright Act on how to handle that. But you just need to know that orphan works are treated differently than other works. Okay, we'll keep going here. So, okay, you can repeat after me. A copyright arises upon creation and fixation in an original work of authorship in a tangible medium. So when you write your great novel and you save it to your hard drive, you have now fixed your novel in a tangible medium. Under the Copyright Act of 1909, which was superseded in 1978, if you didn't register your copyright, it was lost on first publication without copyright notice. And it was very draconian. And you can see that Robert Crumb's famous Keep On Truckin' was created as a poster. And his manager decided that he wanted some business cards. And so on the posters, he had the printer print a bunch of business cards along the side, but he forgot to put on the R in a circle. And a trial court held that Crumb lost his trademark in Keep On Truckin'. Fortunately for Crumb, it was overturned by the Ninth Circuit, but for a period of time, he did not have a copyright on Keep On Truckin', which I think is one of the funniest graphics around. Okay, we'll move on. And, oh, and by the way, I don't think there are any works left that are still protected under the 1909 Act. They've all gone into the public domain because of its own terms. Okay, why do we have registration? Well, it's under the law. In 1976, the Copyright Act was adopted and became effective in 78. And it protects all of the copyrights created on or after January 1, 1978. So let's move forward. Okay, registration. Now, I said that we didn't have to register copyrights under the 1976 Act, and that's true. You don't have to. Your copyright is protected upon what? Creation and a fixation in a tangible medium. However, any work that's created in the United States by a US citizen, anywhere, the copyright is not enforceable in federal court unless it is registered. Oh, so you do have to register your copyright. No, you don't, unless you want to enforce it. If you think you want to enforce your copyright, register it. The protection afforded by copyright is really enhanced under federal law, and there's a good reason for it. The Library of Congress is empowered to collect all of the creativity in the United States that's ever occurred. So if you create something, then the Copyright Office wants you to register it. If it's an unregistered work, they still want it. or I mean, if it's an unpublished work, they still want it. If it's published, then they want 2 copies of it. So when does protection arise? Well, that becomes important. If you don't register your copyright and I infringe, you lose a lot of rights. So what you want to do is you want to register your copyright in an unpublished work when it occurs, or within 3 months after a published work. And then we can move on. And that really becomes important, and we'll talk about why. If the infringement occurs of a copyright, then before you've registered, then all the copyright owner can recover is injunctive relief and the infringer's profits and actual damages. Now that may not compensate a copyright owner, and I'll tell you why. Let's take, for example, someone copies your image on a t-shirt and sells it. And you have not registered your copyright. And you have to sue them to get them to stop. Well, you can do that. But under the federal law, you are denied your opportunity to get statutory damages, and you're denied your opportunity to recover your attorney's fees. So your copyright infringer may not have made any money from selling the t-shirt, and your cost of going after the infringement may vastly exceed what you would recover from the copyright infringer. So we'll move on. And think of the boardwalk, well, it used to exist in Jersey City, where people set up all kinds of shops selling illicit merchandise. And I had a situation with a client who had a copyrighted work and trademarked. We had both in a particular t-shirt design, and it just wasn't worth their while. So we put together a consortium of a number of owners of copyrights in t-shirts and all, and we're able to go in together and get a court order on a preliminary injunction, and had the marshal go in and seize all of the merchandise. And it was amazing when we did that, how many people started running away from their shops along the boardwalk. Okay, statutory damages. If you've registered your copyright, then the infringement occurs. So we have a timely registration. Your statutory damages are $700 to $30,000 for each copyright infringed. So if somebody's knocking off a t-shirt, the court could well award $30,000 for the infringement of that copyright. Not all of the infringements, but the copyright itself. However, if it's willful, and believe me, being willful is not too hard to prove in copyright litigation, then statutory damages are up to $150,000. And that's significant, because that's a big deterrent to somebody who is infringing a copyright. And you can recover your attorney's fees. Now, I've had a lot of copyright litigation over the years. I will not take a case that does not have a copyright registration in place before the infringement. Why? Because the copyright owner will not recover enough in the litigation, for the most part, to cover their attorney's fees. So basically, trying to protect their work, they're financially going backwards. However, if I have a registration, then the likelihood is I will be able to recover my client's attorney's fees. A good example is many years ago, a photographer sued General Dynamics for an infringement of a work that he had, a photographic work that he'd taken on his back porch in Athens, Ohio, when he was a graduate student. And General Dynamics was in the crapper with the Congress and wanted to do a superordinate values campaign to improve its image. And so it did a series of advertisements. And the first one was a picture of a wheelchair on the porch of Franklin D. Roosevelt, and it was his original wheelchair. But we were able to prove in trial that even though it was a different porch and a different wheelchair, they copied all of the elements of the original photograph and all of the rhetorical arguments that were found in that photograph. And so my client got $60,000, but the legal fees were $80,000. So if we had not had a registration that was infringed, then he would have been going backwards. So as a result, he was able to recover both his attorney's fees and his statutory damages that were awarded for the infringement. Actually, we elected not to go with statutory damages, but we went with actual damages, and the $60,000 was the amount attributable to the fees paid to the advertising agency for the ad. And by the way, that ad ran in the Wall Street Journal full-page ad. So it was a significant loss for General Dynamics, and they ultimately had to send us the original image that they had to take down from the boardroom wall. So copyright can have big teeth. And then we'll keep going. Okay, notice. Now you don't have, just like registration, you don't have to have notice. But it's good to have notice. Why? Because if you don't have notice, then somebody could claim that their infringement was innocent. However, if the work has notice affixed to it, then the other elements of copyright damages comes into play. The notice is not hard. See in a circle, 2020 claimant name, or whenever the date of the creation was, and that's all that's necessary. You can also use copyright or COPR rather than the copyright notice. And if it's like a birthday card, you don't have to have the 2020 on it. All you'd have to have is see in a circle plus the claimant's name. So that's what it is. Now you can also add to a literary work, all rights reserved, which meets the requirements under the Buenos Aires Convention, which has to do with copyright protection in Latin America. Okay, we can move on. Okay, registration is straightforward, but not simple. You file a registration application with the United States Copyright Office. It is examined, but the examination is pretty loose. You have to fill out the form correctly, and you have to make the proper identification of what the work is. You have to say whether it's published or unpublished, and then you have to provide either one copy or two copies of the work, depending on whether it's published or unpublished. We'll move on to the next. Okay, filing fee is 45 bucks. If it's a different filing, it's 65, and if you file on paper now, it's 125. So it's not extraordinarily expensive. A lot of photographers whined and sniveled that they couldn't possibly protect all the photographs that they take in a single year. And so we do have some exceptions now in the copyright fee for photographs where they are all created and published at the same time, and that you can file them under a unified filing. So that's a possibility. And tell you the truth, graphic artists and photographers are the worst. I've had more instances of clients or people coming to me to become clients who want me to protect their work, and they didn't register it, and I've rejected it. And they're usually a photographer who's taken a bunch of pictures, and somebody takes one of their pictures and then makes a copy of it, or a lot of copies. And the other is a graphic artist who creates, and has to, in general, create an entire program for a client to show them what they're thinking and what they're offering to have the client do. And the client will say, well, we're not ready for it yet. Then 6 months later, the graphic artist sees their work on their business, on the business cards and the letterhead and in advertisements, and they were never paid. This problem is, of course, they didn't register, so they don't have a right to recover attorney's fees, and the damages are really insignificant. What they would have charged to do the artwork is not as significant as the cost of going after. So a lot of times they just have to walk away from it. So graphic artists should always be encouraged before they disclose their work to file a copyright registration on the unpublished work. And that way, when somebody says, okay, fine, but we're not ready to do it, all they have to do is send them a letter saying, thank you. I understand that you are not going to go forward at this point in time. I do have to remind you that I have a copyright registration on my work. Okay. And that goes for a lot of things where you're having to show what you're doing to a third party before you actually are engaged to do the work. Okay, let's move on. All right, look at those dudes. We're going to talk about the Millennium Copyright Act, which is very interesting. It was adopted first in 1996, and then it was brought forward more recently. It is complex, takes up a lot of space in the Copyright Act. In fact, everything in the Copyright Act takes up a lot of space except for the 6 rights that I read out to you earlier, which takes up 1 page. All the rest of it are exceptions to that 1 page, including the 6 rights. The big element, and the Digital Millennium Copyright Act is really to protect your service providers, the website, the hosts. The big thing was provisions for issuing content takedown, and it protects, the internet host because it's not their contact. It's not their contact. It's somebody else's contact. So if they take it down, then they're okay. And the takedown notices can be abused or they can be used appropriately. A lot of times they're abused because a takedown notice will be sent out for competitive purposes, but they're really not an infringement. But the cost of having to deal with the takedown notice is extensive for somebody who is a small company and having to work with it. So a lot of times they just simply change what they're doing. However, it does have its purpose. And what you're looking at is LinkedIn, Park. These are the 3 guys, and I really hadn't heard of them before. Why are they famous today? Because one of the Trump campaign on the internet utilized one of their songs without license. They sent out a takedown notice, and the content was taken off of all of the social media accounts where it was being run. So in that way, a takedown notice can be a very powerful tool to protect intellectual property. So you can remember that if you get a takedown notice, it sometimes can even be by a troll, and they simply do a takedown notice and they send you a letter saying if you license the work, then you can put it back up, and the license fee is somewhat nominal, but nonetheless, it's illicit. Okay, now let's talk about trademarks. Okay, trademark law is fun. At least I think it's fun. Trademark rights are established under both state and federal statutes and under the common law. So how does that happen? A trademark right arises by use in commerce. That's all you have to do, use it in commerce. Use of a trademark within a single state, Vermont, gives rights to local trademark rights. and enforceable only under state law. Use of commerce in interstate and foreign trade or trades with the Indian nations allows the trademark owner to seek registration of the mark with the United States Trademark Office. And that registration is effective nationwide in all of our territories and possessions and is enforceable in federal court. So there's really two kinds of trademark applications. The first is a 1A. And let's move to the next slide. And the other is a 1B, which is an intent to use trademark application. Prior to 1989, federal trademark rights could only be created by actual use of a trademark in commerce. After 1989, a federal trademark application can be filed on an intent to use basis, so long as the intent is to use the mark in commerce, controlled by the commerce. Again, interstate commerce, foreign commerce, and commerce with the Indian nations. So indeed, we don't have any significant Indian nations in Vermont, but you get to a state like Montana or Washington, and a lot of trade goes back and forth between places in the state with a Indian tribe's nation, and that counts for federal registration. Commerce, again, solely within a state does not count for federal registration. And we can move on. So how do we do this? Well, we have to file an application, either based on 1A or 1B, and the applications are actually almost identical except for a box. And you click if it's a 1A or 1B. And it's got to comply with the regulations set forth by the Trademark Office. And as with everything, when you're dealing with the federal government, you have to pay a fee. So the application, whether 1B or 1A, is examined to determine whether the mark is qualified for registration. And that is simply, it's not generic, descriptive, deceptive, immoral, or otherwise disqualified. Think of SLANT, which was a Supreme Court case last year, where the Trademark Office denied the right to the band to record SLANT because they said it was immoral and disparaging, and the Supreme Court said, no, they have freedom of speech, they can register it. And then the other big test is whether the mark is confusingly similar. The actual test is likelihood of confusion, but it's easier to talk about confusing similarity with marks that are already registered for comparable goods or services. What happens is there is a trademark principal register, and all the marks that have ever been registered are on the principal register. And the Trademark Office can search the principal register looking for existing active marks. If the mark has been canceled for any reason, then it comes back where you can go ahead and file. And we have an instance, at least I have an instance here of the client in Vermont who lost their trademark registrations because they failed to file 8 and 15 declarations of continued and continuing use, so all their trademarks were canceled. Somebody came along from another state, picked up one of the marks that they used and registered it. Now, we could have potentially gone after that mark to cancel it, but a cancellation can be several $100,000, and most businesses really don't want to have to pay that amount of money just to cancel a trademark registration. So they have allowed that use to continue, but we've trademarked all the way around it. So we've got Moo about as protected as we can. So we'll keep going. So what does it take to do an ITU? Well, you file the same form as you would if you were already using it. You have to have a bona fide intent to use the mark in commerce. When you file your intent to use, the mark is examined, and with both a 1A, actual use, and 1B, intent to use, the mark is examined, and if it's found allowable, then the mark is published in the official gazette for opposition. Now, the benefit of a ITU is it gives you priority over other marks from the time that you file your trademark application. So if you're planning to launch a product or a company, then it's really a good idea to file an intent to use. One, you get the examination, so you know that your mark will be allowed and you're not going to be necessarily contested by anybody else or stumble over somebody else's rights. And you have a constructive filing date of the date you filed your application. So even if it takes a year or two for you to actually finalize use of your mark, you've protected it. And we can move on. So just a bit to note, it's not quick. The office generally tries to respond within 3 months and tries to get an application either issued or allowed within 13 months. It doesn't always happen, but the trademark office has been much more functional during the pandemic than a lot of other places in the federal government. So, what is opposition? You've heard me talk about it. And opposition is when it's published in the official gazette. And that used to be a paper, well, it still is actually, a paper book with several pages of applications every day being published. It's now published online. And that allows anybody 30 days to file an opposition if they believe that in some way they're going to be harmed by that trademark. So that can happen without, somebody doesn't even have to have a trademark registration to file an opposition. So good example. I have a client who is right now waiting to see if the opposer will in fact file an opposition. The mark is spin tray. The potential opposer owns a registration for spin. And in the meantime, or the last several years, spin has become a generic term for what? A stationary bike. So I'm kind of looking forward to seeing how that, if we're going to have an opposition. The unfortunate part is that the opposer was in bankruptcy and came out only to get PPP, and then it's going to go back into bankruptcy. So I don't know if it'll have the financial wherewithal to do an opposition. But there's where somebody is trying to stop a mark that's not related to their own mark directly, but indirectly. And in fact, the opposer would be Mad Dog Athletics, and they make spinning bikes, but Spin Tray is only manufactured and designed to work on a Peloton. So there you have it. Okay. If the mark is not opposed, then at the end of the 30 days, it is allowed and will not be registered, but you have to begin your march to the market. And we can go on to the next one. Now, the march to the market is simply this. You have your notice of allowance in hand, and you decide how you're going to use the mark in commerce. And that means that you're going to have to provide a specimen of use, of actual use in commerce to the trademark office, along with, again, a fee showing that you have completed your march to the market. You have 6 months in which to march. Well, no, you actually have more time than that, because if at the end of the 6 months you haven't completed your march, you can get an additional 6 months. And then if you need more time, you can pay for and get an additional 6 months. And you can keep doing that up to a full 3 years after you receive your notice of allowance. They're granted in 6-month increments with, of course, a fee.
at the end of each 6 months. So you've got a lot of time to develop the use of the mark in commerce, which is also good because it also gives you a lot of time to develop your advertising, marketing, product, whatever you want to use the trademark on. So it's not like you have to have it ready to go as soon as the opposition period has expired and you get your notice of allowance. We can move on. Okay, R in a circle. A lot of confusion over the R in a circle. A lot of people think it's like a copyright notice that, and they can just use it on anything. No. The R in a circle is the statutory symbol that says I have a registration for this trademark with the United States Patent and Trademark Office. Now, before a trademark is registered, you can use a TM or SM, which indicates that it's a service mark or a trademark. It has no legal significance. It simply tells the world that you claim whatever it is that you're using it on is a trademark. And a lot of people will do that even though it's not a trademark. However, once your federal registration is issued, you can and should use the R in a circle. Again, why? Same reason as you use a copyright. It is notification that is a trademark, and if you use your notification, it avoids a defense of innocent infringement. So if you've got a registered trademark and you use your R in a circle, or you could use a whole different ways of doing it, and I'll explain a little bit of that in a second, then you can't have somebody come along and say, geez, I didn't know that was a registered trademark. So it avoids the defense of innocent infringement. Now, other things you can do is you can stick registered U.S. trademark. You can, and I have a lot of clients do this because they don't want to use the R in a circle everywhere. If you've ever been to a Red Robin restaurant and looked at their menu, every burger has an R in a circle after the name of the burger. Why? Because their general counsel was a trademark lawyer and he loved filing trademarks. So you can put down, and it doesn't have to be in huge letters, somewhere on the back of a box or on a menu or a brochure, whatever, that blah, 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 and blah, blah, blah are registered trademarks of blah, blah, blah. And that's all you need, so that you're giving notice to the world. And you can also do it for unregistered trademarks as well, if you have unregistered trademarks, but you also want to give notice. So that works as well to tell the world that you are claiming or have a trademark registration in a trademark. Okay, we can move on. Maintenance. Oh, yes. Patents require periodic payments of maintenance fees to maintain the patent until its term expires. Same way with trademarks. Not true of copyrights. Copyright lasts as long as I've said. Life of the author in 70 years. However, with trademarks and patents, there are fees. And the first one for trademark is between the 5th and 6th year after registration. You have to file declarations under Section 8 and to say that the mark is in use, and you pay a fee. Now, they're not huge fees, but you have to pay a fee. And I won't tell you what the fee is, because as soon as I do, the trademark office will probably change it. If you don't file your Section 8 declaration, your trademark registration will be canceled. Now, you can also file a declaration under Section 15 of the Act, and that says that the mark has been continuously used for the past 5 years with no adverse claims against ownership. So nobody has come forward and said, your trademark you don't own your trademark. I own a similar trademark, and your trademark is likely to cause confusion. So If that hasn't happened, you can file your declaration under section 615 and the mark becomes incontestable. And that gives you certain additional protections, or at least presumptions, under the trademark law, but it doesn't protect it totally. It sounds really good. You know, my mark is incontestable. But if the mark has become generic, like aspirin or elevator or escalator, then you could lose your mark. So the trademark is perpetual, unlike a patent or copyright, which has a defined term. Trademarks will continue to exist as long as you file your renewal every 10 years, forever, or as long as the United States should remain in existence. And so the renewals are due at the end of between the 9th and the 10th year. And I've got clients that, gee, I won't tell you how many we've done, but who have filed their renewals every 10 years for a long time, and their trademarks continue to be in existence. Again, if you don't file your renewal under Section 8, your trademark registration will be canceled. Now, that doesn't mean your trademark rights are canceled. It simply means that your registration is canceled. You continue to own your trademark rights, but just as if somebody scrapes off a portion of one of your canceled marks, now you have a problem because they hold a registration and you don't, even though it's your trademark. Okay, moving on. Now, can I lose my trademark rights? Absolutely. One is if it becomes generic. Let's go back to spinning and Mad Dog Athletics. Spin has become used over and over again in the media as descriptive of a stationary bike. Other marks, escalator, elevator, aspirin, all became generic because the trademark was used in the public domain as a noun rather than an adjective. Remembering, a trademark is always an adjective. If it becomes a noun, then it becomes generic. So that's why I like to remind people, when you see the R in a circle, take a deep breath and say, whatever it is, brand product. So if we want to talk about Moo-Doo brand compost. And we don't call compost Moo-Doo. Why? Because it will become generic if it gets used that way. So a trademark owner has to protect their trademark from becoming generic. The other is you can lose your trademark by non-use. And let's say somebody stops using a trademark for a period of time. If it goes beyond 3 years, there is a presumption of abandonment. Even though its registration may still be effective on in the trademark office, its non-use means that it may have gone abandoned. Okay. You say, well, so-and-so hasn't used their trademark for 3 years, now I can use it. No, because the law says that abandonment is not just the non-use of the mark, but also an intention of not going back again and using the mark. So you can have a mark lie fallow for a number of years, but the trademark owner has not abandoned it because they have an intention to resume the use of that mark in commerce. And so that's not a real high hurdle to have to prove. And if you're in that situation where you want to discontinue use of a trademark, but you don't want it to go abandoned, what do? Well, you make notes periodically. You may have a board of directors meeting where you bring it up and they say, no, we're not going to, we're going to think about using it again in the future. So you can have proof that that's what you're going to do. And the resumption of use will avoid abandonment if somebody else seeks to have your trademark rights voided because of abandonment. So once it becomes generic, it enters the public domain. So if you have a trademark and people begin using it as a noun, not as an adjective, you want to make sure you protect it. Xerox always advertises that Xerox is a brand, and you do not Xerox something. You make a photocopy on a Xerox copier. And that's what why? Because they're trying to avoid it becoming generic, even though the rest of us will say, oh, I just made a Xerox copy. Okay, we'll move on. Okay, moo. This is an interesting mark because we don't have a registration on the word moo. That's because somebody else has a moo trademark registered for compost. But what we did get registered was moo in a circle, which is what we call a word mark plus design, mark plus design. Now, I've had a number of situations where somebody has sought to register a moo in the field of compost or fertilizer or whatever, and the trademark office has rejected the application based on moo in a circle. Why? Because there is a likelihood of confusion between what the applicant is seeking to register and that graphic design mark. So you can broaden protection for a trademark if you indeed do some other registration, such as the mark plus the design, because even though I can't protect moo, I can protect moo going forward with a registration to something like this. And that's true of almost any other trademark where you want to keep it protected, even though you may not be able to simply do the word mark by itself. Then we can move on. Okay, unfair competition. Unfair competition has a very broad definition. The federal is unfair methods affecting commerce and unfair or deceptive act or practices in or affecting commerce are unlawful. Boy, that is about as broad a statute as you can find. The Vermont statute is a little bit narrower because it only declares it unlawful, but they're identical, and the acts that we're going to look at in terms of violating unfair competition violate both state and federal, because the states, I think most of the states adopted the Uniform Unfair Competition Act, and that is what you're seeing for Vermont is essentially what all the states have in their unfair competition provisions. The federal act is found in the Trademark Act, Section 43. And so a lot of times when you have a trademark infringement, you will also file a 43A Act, 15 U.S.C. Section 1125A, for unfair competition or defective or deceptive acts or practices, because that broadens out the claim you're making. So even if it was found that they were not infringing the trademark, they could be found to be conducting unfair acts or practices. And we can move on to questions. So.
Awesome. Does anyone have any questions? I have a few, but I'd love to give others a first crack.
One of the things that a lot of people have questions over enforcement. If we got into enforcement of intellectual property, that really is a separate discussion, normally directed to lawyers, but I think it's important for non-lawyers to understand what goes on. And I would be happy to put together a program on enforcement if anybody would like to have one. The other thing is arbitration and mediation. And there's a lot of questions about arbitration and mediation. We talk about it all the time, but I'd be happy to put on a program about mediation so you have a better feel for what goes on in mediation. I think it's important to mediate before you litigate or arbitrate. Arbitration is important because it's a way of, by agreement, defining how you're going to resolve your dispute without having to go to court. And it can be far less expensive than doing an actual courtroom process.
Awesome. Peter, do you have a question?
Yes, thank you. So I just had a question about copyright content as far as a blog or just online content, specifically online writings, like a personal blog that gets kind of continuously updated.
Well, okay. First of all, your blog is copyrighted. Now, the mere fact that you did it, you saved it to your hard drive, you posted it to the internet, it is protected. Now, registration. Registration for blogs is covered by the Copyright Act, and depending on how you're blogging and how often, what you're doing, what your medium is, will govern how you're going to copyright by registration your blog. It's just like a newspaper. You can do a compilation. You can also do, of issues and then do one registration so that you don't have to file a registration for each blog and pay $45 a day for the privilege of blogging. And if you go into the Copyright Office, copyright.gov, and go into the circulars, of which there are many, and they're well written, partly because the Copyright Office is part of the Library of Congress, so somebody there knows how to write. You will find all the information that you need to know about how to register your blog.
Okay, but so basically I could register it, let's say sometime this year, and then which would cover blog posts I write next year. Is that correct?
Oh, wait a minute. You couldn't file something this year to cover a blog next year?
No, so what I'm saying is what I'd like to do, right, is have a blog that I do copyright once, but, you know, not one which I'd have to copyright every time I have a new post. So, you know, as I understand, you know, to avoid doing this, there should be some type of like registration that I could go for, which would, you know, which would copyright any more writing that I do instead of, you know, this $45 charge for every post I put up.
Yes. But
okay.
You have to, oh, there you go. You have to be able to, I'd have to see your blog, but yes, you can register your blogs and you can do one that would cover if you want to do it, you could do it every 3 months and then have a relation back to the beginning one and register them all. There is some, depending on how you published it, there could be an issue, but for the most part, it's just like a newspaper. You can do that. And newspapers will file their registration every 3 months.
Okay, fair enough.
One question that came in the chat, Rex, is from Yvonne, who said, how often does the USPTO find likelihood of confusion in different classes? For example, a registered trademark in class 40 for custom clothing versus a similar one being registered in class 35 for the advertising of tailors and seamstresses.
So, no more questions?
Um, did you hear my last question, Rex?
No, I don't. If somebody else has questions, they can always contact me.
Someone has a question about the USPTO different classes.
Okay.
Um,
Or
and they're wondering
yeah.
if the likelihood of confusion between different classes. For example, a registered trademark in class 40 for custom clothing versus a similar one being registered in class 35 for the advertising of tailors and seamstresses.
Okay, let's go back to the test. Likelihood of confusion. We have classifications presumably to distinguish channels of trade or goods one from another, so that you can have more than one trademark depending on which channel of trade it's in or which classifications it is in. But you have to look at the nature of the trademark. For example, I don't know how you could possibly file Coca-Cola in any class without infringing Coca-Cola's trademark, regardless of what you're trying to do. So yes, there is different classes, and you can have the same trademark in a different class, and it won't be likely to cause confusion. Why? Because the channel of trade is entirely different than the other channel of trade.
Awesome.
I mean, a good example is Phoenix Feeds Organics. It is registered for cattle feed or livestock feed. You have Kester and Prulux, which is now owned by Nestle's, and they have organics for pet food. So we have an agreement with them that there's not likely to cause confusion, and they agreed to the registration of organics as long as we always use it with Phoenix Feed. So here again, you're in two entirely different classifications, but Nestle's did not want any other organics anywhere near feed, because they may want to expand their use of the mark into something other than pet foods, organic pet foods, or whatever. So that becomes important in terms of what is the mark, how is it being used, and what is the channels of trade.
Awesome. I have one question just on trademarks. So because it takes a long time, 3 to 13 months, would you recommend applying for the 1A intent to use first as a way to just start the process?
Yes.
Okay.
Doing an intent to use is a good way of putting your finger in the dike. And, you know, if you start using a trademark, not even on necessarily on goods or services, but start talking about it in the public arena, somebody else can say, gee, I like that. And they could file a registration for an intent to use, and what would happen? You're now subject to their prior claim of right.
And then also, is a federal trademark some sort of umbrella in terms of federal versus state, or should you be filing both?
Well, I don't like state trademark registrations because they're very weak in the sense that they only protect the trademark in the state and not in any other state. So if somebody can possibly file federally, that's what they should do. And the federal registration covers all states.
Awesome. Is it more expensive because of that?
Oh, yes. Not a huge amount. Your federal prosecution will run, you can run, you know, depending on how you do it, and you can do it yourself, come to think about it. Your federal filing is $225 if you do it online. State registrations are usually $100, depending on what state you're going in.
Mm-hmm.
But your protection is limited. And if you're using your trademark in other states, but you only have a state registration, you might find yourself being precluded by someone else filing a federal registration. And even if you're not using it in another state, if you only have a state trademark registration and I file my federal registration, let's say in New York, then I am precluding you from ever using your trademark in New York if you haven't used it in New York, because I can preclude you from using your trademark in any area that you have not already entered.
Awesome. That's awesome and helpful. Does anyone else have a question for Rex?
I just had a very quick one, maybe just to kind of confirm what you said. So say I have a website where I'd like to declare some trademarks which I haven't registered yet, but nonetheless, so with the TM. So is it fine if I just have, let's say, a hyperlink to a page where I state which of the terms I would like to or have been trademarked, and that's good enough? I don't need to kind of reproduce the TM every single time one of these, hopefully trademarks is mentioned.
Say that again.
So all I'm saying is when you have a trademark that you haven't registered yet, right, you can put the TM, is that correct? Showing intent, right? And so, but to avoid doing that, you also mentioned that we could just have a notice that states as much.
Yes.
Is that okay? And so, if that notice is, just like, let's say next to the copyright where you select the copyright, you have a link to trademarked, to the trademark terms you have on your website, which is, let's say, a link to a page, with a couple sentences stating which terms are trademarked, and that's it. You don't have to. So is that good enough so that you don't have to have, the TM next to every word?
Absolutely.
Okay.
What you have to say is blah, blah, blah is a trademark of blah, blah, blah.
Okay.
Now, you have to remember that you've got to have it as a trademark. It can't be just, they have to be able to function as a trademark. So if you have just a word or something, it may or may not be a trademark.
Right. So something that could, I guess that will plausibly be accepted as a trademark.
Yeah.
Right. Okay.
And even if it wasn't registrable, you can still claim it as a trademark and still use it as a trademark.
Mm-hmm.
Now, you might infringe somebody else's trademark, but that's a whole different issue.
Okay. Yep. Thanks.
Okay, Rex. Well, thank you so much. I'm going to wrap it up because we went a little over, but I will certainly send out the recording and your contact information to everyone that joined for the call. And thank you for all of this knowledge. It's really helpful to hear your perspective and take such a deep dive.
My pleasure. As I say, I'm always happy to answer simple questions, things like that, because this is a service to businesses in Vermont as best I can do.
Lovely. Well, I hope to see you soon, and thanks everyone else for joining.
You're so welcome. Take care, everybody. Stay well.
Yeah, you too.
Thank you, Rex.
Bye.